So we had litigation on a number of matters where some of the accused perpetrators were alleging due process violations.
Yes, in a lot of instances, the issues became how much due process do respondents or those accused of sexual misconduct get, and we handled a number of Title IX matters in the investigation phase where the issues were due process, fairness, the element of bias. Because this is an investigation handled by the university, was there bias? Was the university biased in favor of one side or the other, or biased in favor of the university in terms of the outcomes of the investigations of sexual misconduct? And so there was lots of discussion. These issues were litigated in court. We were involved in some of that litigation. And as things stood at the end of the Obama administration, there were a variety of sort of levels of due process that were required by the courts, depending on where the school was located. For example, in the Sixth Circuit, which covers the upper Midwest, the Court of Appeals required a fair amount of due process, something akin to a judicial proceeding in college and university Title IX proceedings. And this is really tough on a college or university because they're educational institutions. They're not courts of law. And so this idea of introducing due process into Title IX proceedings really made things difficult for colleges and universities. And made creating sort of bright lines and clear rules really difficult. Other courts, like the Fourth Circuit, where we were located here in Virginia, were more deferential to colleges and universities to come up with their own process for investigation, as long as there were not obvious indications of bias.
So from the 2014 to 2018 timeframe, there was a fair amount of public advocacy, a fair amount of commentary and analysis that was pushing for changes from the earlier Obama standards, adoption of more due process rights for the accused, and injection of more formalism into those hearings. Had you seen that in your practice over time?
I think so. In fact, even in some of the court proceedings on Title IX here in Virginia, we were starting to see elements of due process creep into the court's decisions, in the sense that the Department of Education guidelines and the Title IX regulations did not require formal due process, but the court seemed to be implying that due process was required. In part, I mean, let's not dismiss this as inconsequential, because the consequences to someone accused of a Title IX violation are significant. So combining that with the either lack of due process or the informality of college and university investigations prompted a number of courts to sort of revisit this idea of how much due process was appropriate for those accused of Title IX violations.